going to briefly introduce, mostly as a method to let everyone get in. So I am Torrin Liddell. I am a researcher at the Indiana Public Defender Commission, a state agency for public defense. But I am here as a member of the IDRA board. I'm now the secretary of the IDRA board, which means I manage the Google Drive. That's what it means. So I'm not going to spend a lot of time talking. I just wanted to thank you all for coming, and especially to thank our presenters for coming to present at our third annual spring online conference, and to thank you all for being part of the IDRA community. We've already got a huge variety of talks in just our first two panels, so I think this is going to be a great set of talks for this conference. So with that said, I will pass it off to the presenters and let them introduce themselves and tell us what they're here to tell us about. So go ahead.
Should I just?
Yes, please go ahead, Amanda. Sorry.
Okay.
Yeah, and you can feel free to command the screen whenever.
Awesome. Okay. So I guess I'll share my screen now.
Perfect.
Great.
Yep, looks great.
Awesome. Okay. So hi everyone. My name is Amanda Izes, and I'm excited to get to kind of start off this session with you to talk about work that myself and Professor Alisa Smith have been doing on comprehension in misdemeanor arraignment hearings, particularly from a linguistic research perspective. And just to kind of introduce myself, for this work, I'm working as a research assistant to Professor Smith. And this project is kind of a larger part of a larger project that's funded by the Bureau of Justice Assistance with collaboration with National Association of Criminal Defense Attorneys. And just for some context, my kind of home discipline is forensic linguistics. So kind of looking at the intersection between language used in and how it, like analyzing language within legal and justice settings. So to begin, just to give kind of a brief roadmap of the discussion, I'll start by talking a bit about the history of linguistic research regarding comprehension in the legal system, primarily in the reading and waiving of Miranda rights. And this research will kind of help to situate the new research we're discussing in this presentation within the larger field of forensic linguistics, as well as kind of relate it to other research within studying the justice system and criminal justice more generally. Then I'll move on to discussing our research questions as well as our findings so far. And then finally kind of summarize and give some of the recommendations we've been thinking about for how these findings could maybe be applied in the real world. Okay, so it's well documented that legalese is difficult for both lawyer and layperson to understand. In the field of forensic linguistics, again, my kind of home, this has been studied across the justice system with a particular focus on Mirandization as well as police interviews and interrogations. In analyzing linguistic complexity of the law, the conversation surrounding its enforcement, we see that defendant comprehension or kind of civilian entering the legal system comprehension is often hindered from the very beginning of their interactions with the legal system or justice system. So for example, in the realm of Miranda rights, Roger Shai and others criticize the Miranda rights for their linguistic complexity. Many verses of the rights contain multiple embedded clauses that kind of complicate one's ability to follow their logical meaning. One easy example to keep in mind is kind of the presence of conditionals or if-then statements within the rights. So like if you cannot afford an attorney, one will be provided to you. And then another thing Shai points out is the presence of homophones that may be difficult to understand, given that the average reading level of people involved is typically 6th to 8th grade level, because that's the average reading level within the US. So for example, even the use of the word waive can add confusion. So bolstering this idea that there's kind of a fundamental linguistic confusion in these rights, it's also been found that misunderstanding of Miranda rights are really very commonplace. So for instance, a study by Rogers et al. Found that 20% of prospective jurors, 26% of undergrads, and 31% of defendants wrongly believed that silence could and would be used as incriminating evidence. this misunderstanding, as you can imagine, could play a pretty determinative role in whether someone decides to waive their rights or not. Finally, outside of kind of the basic language itself and moving into kind of sociolinguistic interactions with legal and law enforcement professionals often further obfuscates understanding for civilians or people being Mirandized. When asked a question, it's pretty commonplace for an officer to respond by kind of repeating the formally stated Miranda rights or whatever the relevant section is of them. And while this may protect the officer from later appeals, it doesn't actually get to the heart of the misunderstanding or confusion that the person being read their rights is asking about. So this lack of understanding of rights extends beyond just police interrogation and Mirandizing into the realm of what we're here today to talk about, which is misdemeanor criminal courts and the waiving of rights in a plea deal. So when pleas are taken, they must be done in a knowing, voluntary, and intelligent manner. And Justice Clarence Thomas describes this further and better than I could, differentiating it from simply competence in trial in saying the focus of competency inquiry is the defendant's mental capacity. The question is whether he has the ability to understand the proceedings. The purpose of the knowing and voluntary inquiry, by contrast, is to determine whether the defendant actually does understand the significance and consequences of a particular decision. In a study conducted by Redlick and Summers, the majority of defendants that they tested claimed, which was 99% of them, claimed to understand their charges, the plea process, and plea deal. But when tested, the percentage of understanding fell to below 60% for over 2/3 of those individuals tested. Redlick and Summers argue that this indicates a failure of the plea colloquy hearing proceedings to adequately ascertain whether a knowing and voluntary plea has been made, even if it's pretty clear that the individual is competent to stand trial. The research that we've done that we'll be discussing today seeks to build on that assertion and add insight into exactly where comprehension may be hindered during interaction between judge and defendant in a misdemeanor hearing. So specifically, this project seeks to utilize a linguistic lens to add insight to the realm of defendant comprehension of waiver of rights for unrepresented defendants in misdemeanor criminal court. A linguistic approach to examining this defendant comprehension in criminal court settings is kind of novel in itself and exciting because it allows us to use raw conversational data, like the data used in the Mirandizing studies that I just mentioned, to really pinpoint what specific behaviors, conversations, or even kind of phrases or bits of language used in an arraignment hearing actually act to help or hinder understanding of the defendant. So specifically, we ask, one, what is the reading comprehensibility of misdemeanor court forms? So request for counsel and plea waiver and the transcribed text of video advisement of rights and procedures. And then we ask, employing genre and conversation analysis to linguistic approaches, how do the plea colloquies and judicial discourse encourage or discourage comprehension of rights waivers and case outcomes by unrepresented misdemeanor defendants? So basically asking the question, how does language used during these trials help or hurt defendant comprehension? And just as an important note, as we move into talking about these questions, linguistics doesn't allow us to read minds. So this work can't say whether or not a defendant is actually understanding, but what it can do is look at the language used to determine if confusion is expressed by the defendant, if the defendant is requesting clarity, and how judges can respond to that confusion, understanding, or those requests for clarity. So basically, it helps to get an understanding of how defendant comprehension is kind of managed within this environment and how that management affects ultimate whether they understand or not. And then also a note is that all of the data used for these questions and analyses comes from a larger project, as I mentioned, and it sorts from a smaller county court and larger county court. Okay, so getting into the first question regarding reading comprehensibility. This question examines materials provided to defendants prior to and during their arraignment hearing. It's important because if defendants can't read or understand these materials, they're already going into their hearing very disadvantaged in terms of comprehension and understanding. So we analyzed the form application for appointment of counsel, rights waiver form, as well as transcripts of the video recorded advisement of rights and procedures that was used in the smaller county court. So to quantify readability of this data, we use the Flesch reading ease and Flesch Kincaid estimates. The Flesch reading ease score provides an estimate for the proportion of adults who can comprehend reading passages, and the Flesch Kincaid score estimates the grade level necessary for understanding, employing a formula that combines sentence length and average syllables per word. And as you can see on this table, it kind of shows you how each score relates to the other. So for the forms we reviewed, we would hope to see the readability scores at or below the general population, which is about 6th to 8th grade. However, the readability scores were much higher, as you can see from this graphic. The request for appointed counsel form had a Flesch Kincaid readability score of nearly a 9th grade level. The rights waiver form had a score of 13th grade, or kind of an early college student level. And the transcribed video advisement had a score of nearly 8th grade. So kind of within that average expected, but still at the very high end. So basically, if the defendants could only read, as we assume, at a 6th to 8th grade level, all of these forms could not be assumed to be fully understood simply because they're too complex. Okay, and then moving on to our second question, that's kind of the larger question in this project. Just as a reminder, employing genre and conversation analysis, how did the plea colloquies and judicial discourse encourage or discourse comprehension of rights, waivers, and case outcomes by unrepresented misdemeanor defendants? So for this question, we examined transcripts of actual arraignment hearings. This included 7 different misdemeanor arraignment hearings of unrepresented defendants who pled either guilty or no contest. 2 were from the smaller county, 5 were from the larger, 3 were female, and 4 were male. And in line with Professor Smith's previous research, they together had an average length of 2 minutes and 49 seconds. So to begin this analysis, it was first essential to get an understanding of how kind of a typical hearing would occur. And to do this, we use something called genre analysis. Genre analysis is, as you kind of understand genre colloquially, a class of, or a genre, as you understand colloquially, is a class of communicative events having a shared set of communicative purposes and similar structures and intended audiences. So kind of within a non-academic realm, it would be something like knowing how to order at a fast food restaurant would be one genre, whereas kind of ordering at a fancy restaurant could be another, or even knowing how to present at a conference and answer questions is a genre that could be studied. So the process of defining a genre is cyclical, as we see here. Basically, exposure to the genre, determine kind of key characteristics and structures, what's required, what's optional, things like that, gain additional exposure, and adjust those characteristics and kind of move on and on. So for misdemeanor arraignment hearings that we've examined, this has emerged as kind of the very basic structure. Because of time, can't go into like all of the nuances, but this is the basic structure that currently exists in our research. So basically, the arraignment hearing starts with the court identifying the defendant, saying something like, "Are you Sabrina?" And then the judge describes the charges and optionally the plea deal. So you've been charged with permitting an unauthorized person to drive. Then the judge requests a plea from the defendant, asking something like, "Do you know how you wish to plead to the charge?" Then the defendant can provide the plea. In this case, Sabrina said, "Plead guilty." Then the judge confirms comprehension in the form of a plea colloquy, which I have not included here because it's much too long for the slide, but we'll discuss in a few minutes. And then finally, the judge provides and reiterates requirements of the plea deal before kind of closing out by saying something like, "I'm going to accept your plea deal. There'll be a withhold adjudication, $100 fine plus 400, et cetera, et cetera." So, and sprinkled throughout this structure, we've noted that there are kind of very optional moments to request comprehension from the defendant. basically always in the form of the question, do you understand? But there's no formal pattern at all associated with when that occurs. So with that structure in mind, we approach the second part of this research question using conversation analysis. So conversation analysis essentially aims to describe how talk makes things happen. So it can be how talk makes abstract things like social structures happen versus even more physical things like the coordination of people and actions. This form of analysis utilizes an examination of raw conversation data. So in this case, the transcripts of the trial of the hearings, to glean patterns between participants. And typically this kind of analysis relies on speech acts, or kind of the idea that speech acts are considered units of conversation that make things happen. So for example, a question is a speech act because it does the act of requesting information from another person. Or a command is a speech act because it does the act of telling someone else to do something for you. So here in this research, because of the structure of an arraignment hearing, questions and their paired answers are of particular interest. And in this case, participants are the judge and the defendant. A key part of conversation analysis that doesn't come up in other types of discourse analysis is the need for very detailed transcripts, because paralinguistic behaviors like overlapping talk, clearing one's throat, if it's a video, even like eye movements matter to the analysis as well. So this table kind of gives you a brief overview of some of the symbols used in the transcripts that you'll see on the following slides. The two that you really need to focus on are just the top two rows. So anytime it's J:, it's indicating that that's the judge speaking, and any other letter is the defendant, and it's just the first letter of the pseudonym that they've chosen for themselves. And then the square brackets indicate that talk is in overlap, or simply there's an interruption happening, and that'll come up in a few minutes. So so there are 4 key findings at this point. The first is that openings, or kind of the way the judge starts an arraignment hearing, vary in pace, information contained, and explicit explanation of the process and charges to the defendant. We can see this in the differences between the 2 excerpts on the screen. So you can see pretty clearly that both of these begin with a request for the defendant to identify themselves. However, they begin to diverge in the judge's next turn, with the judge in the first example simply kind of listing the charge and asking for more detail from the state. However, in the second example, the judge combines the listing of the charge with a fairly extensive explanation, kind of in plain language, of what that charge is, as well as a request immediately for the defendant's plea. This variance in opening of each interaction indicates an overall lack of consistency in kind of the expected knowledge of a defendant as they come into an arraignment hearing. The inconsistency also arguably hinders defendants from being able to adequately prepare for a trial, whether that's mentally or practically. And in addition, this inconsistency also changes how much information a defendant may have before they are asked to decide what their plea will be. So once a plea is made, each judge enters into a nearly identical series of, importantly, yes or no questions that in theory are designed to confirm comprehension. Importantly, the yes or no questions limit the ways in which a defendant may respond or express confusion, because in being asked a yes or no question, their chosen answers are basically limited to yes or no, and asking any question beyond that kind of indicates a deviation from a conversational path set by someone who's a more powerful actor in the situation, the judge. So these questions are kind of step 5 in the genre analysis, what we refer to as the plea colloquy. So won't read them out loud, but you can kind of take a moment to look at them. And then as we move on, the third finding, when the defendant did attempt to expand beyond yes or no in this questioning process, the judge tries to quickly return to the expected path of conversation. So in this example, we see that the defendant attempts to correct the judge in saying, right, no, but I'm an American citizen. So, and the judge quickly interrupts back, telling the defendant that the judge quickly interrupts back saying, okay, I figured you are, but the law says I got to tell everybody just in case. And this moment kind of tells us and potentially the defendant that the deviation is not necessary or encouraged in the context of the hearing. This also provides additional insight into how kind of routine and scriptedness defines the arraignment hearing process, rather than being driven by a need for defendant comprehension of plea deal and consequences of waiver of rights. And kind of as we're proceeding in this research process, what it has said to us is that judges are a bit loose with the introductory information and getting defendants to plea and waive their rights. But once that process is accomplished, they kind of become scripted, and the script pretty clearly isn't for the defendant's benefit or to ensure comprehension, but rather it protects the judge. So similar to officers in Miranda rights, so the plea won't be reversed on appeal. And with that scriptedness in mind, our final point is that when questions from defendants do arise, judges seem to have an inadequate response. So in this example, the judge presents the defendant with the expected questioning of his plea, and instead of immediately responding, as we see in other examples, the defendant responds with another question. What's the difference? And the judge responds again quickly, defining guilty means I did it and no contest means I just want to resolve it. Though this answer is like arguably acceptable, it's also potentially inaccurate in its content. Oversimplifying the meaning and potential repercussions of a no contest plea, this response potentially gives the defendant a false sense of understanding exactly what they're pleading to and what the consequences of that decision are. Because no explicit questioning of understanding from the judge to the defendant occurs before his response of no contest, the judge has no real way or explicit way of knowing with certainty that this defendant fully understands his rights or what he's waiving. So to kind of sum up, the findings discussed in this paper or this project mirror other interactions in the justice system that have been studied through a linguistic lens, such as what we talked about, so the reading of Miranda rights and approaches to police interviews and interrogations. We specifically note parallels in the strong preference for yes or no or closed questions in measurement of understanding during these hearings, as well as the idea that there's some adherence to a script or genre that seems to be valued over providing thorough, potentially like somehow original responses to defendant questions in order to confirm comprehension. Because of the similarities, we argue that some recommendations can and probably should mimic guidelines suggested for other criminal processes. So for example, one recommendation would be to allow the defendant explicit space within the hearing to restate the meaning of their charges and waivers of rights. This recommendation has already been supported to improve comprehension in the Mirandizing process. And additional recommendations, which with varying degrees of feasibility, but still in play, are rewriting or rewording the information provided to defendants via video, written, or in-person medium to suit a lower reading level. And this has actually been done in many areas of the US with Miranda rights. And then the second would be trying our best to shift from yes/no questioning of the defendant during a hearing to a more open-ended structure. So for example, instead of asking, do you understand? The judge could ask, what do you understand about the rights you are waiving? So this could help remove false expressions of defendant understanding during a trial. And that's it. So thank you so much for listening. And as I said, this is a work in progress. So any feedback or questions is totally welcome. And I guess I will hand off to the next presenters also.
So Shelby and I are next, but I want to respect your time, Amanda and Alisa. We have 90 minutes and you've taken 25. So I think if people do have questions, for Amanda and Lisa, I want to make sure they get a chance to ask you.
I will say we will definitely, if you don't have a question now, but if you come up with one, we will definitely hopefully have time at the end. But I just wanted to say thank you for bringing some forensic linguistics here. I mean, I'm sure it's happened. I've not been here that long, but we definitely need more of that at IDRA. Like, we are an interdisciplinary group and we kind of pride ourselves on that. So please come back and bring your friends, because this was super interesting. And I definitely think it's an area that I have not seen a ton on at this group.
Yeah, happy to spread the word. So thank you.
All right. Well, I mean, if more questions do arise, then I'm sure we'll all be able to stay on till the end as well. Perhaps people will ask them at that time. Amanda, Lisa, are you happy for us to continue, or do you have any final thoughts?
I'd say go ahead. Yeah, I'm happy, excited to hear what you guys have.
Take it away, Andy.
Thank you. All right. All right. Well, thank you guys. Thank you guys for getting us started. And thank you to everybody here for being here, 4 p.m. Eastern, at least for those who are over on the East Coast, and joining us. We are so excited to be here. Shelby Sirivore is joining me. She also has her camera on, and we're here from the Deason Center. I'm going to share my screen in any second. Here we go. Thank you. Okay. So we're presenting a bit of a preview of a report that will be coming out this month called Getting Magistrations Right. It's a report about the process in 4 Texas counties for people to get access to lawyers who are accused in misdemeanor cases. The people, that is, not the lawyers, although who knows. The Deason Center is very focused on the early part of the criminal process. We launched last year a campaign that we're calling the Day One campaign, that focuses on what ought to happen in the first day of after a person has been arrested and is accused of a crime. And part of some of the things that we think that ought to happen in the first day after a person has been accused of a crime is they ought to be brought to court. They ought to be told they ought to appear in front of a judge within 24 hours. They ought to have access to an attorney at that hearing, and they ought to also at that hearing have the ability to apply for an attorney to represent them in the rest of their case. As a component of that work, we are presenting this project today. This is a project called the Non-Representation Project, supported by Arnold Ventures. And it has to do specifically with the process of applying for and obtaining an attorney, centering right on that very first court appearance in the state of Texas. In Texas, that first court appearance is called a magistration. So you will hear us from time to time refer to magistrations. In whatever state you are in, when you hear us use that word, think of the time when, right after a person has been arrested and they are brought to court. They might be, depending on where you are, brought to some small local court. It might be a bit informal. It might not have a judge who is a qualified lawyer in it, depending on the state that you're in. All of those things are true in Texas, as a matter of fact. My colleague Shelby and I have visited the places where magistrations take place. And although we are not the only ones to have these extraordinary stories, we certainly do have some extraordinary stories. We have seen in at least one location, a courtroom, which was also a toilet. As well as performing many other functions, it was also the place where the magistrations were taking place. So these first appearances in front of a judge are critical because in Texas anyway, and in a lot of other places, they are in fact the time when a defendant must be told that they have a right to be represented by an attorney, and they must be given the opportunity to apply for that attorney. In fact, the statutes in Texas go so far as to say that the magistrate's actually supposed to assist them with the application in the event, I suppose, that they might be having some trouble filling it out. So we want to find out why it is in Texas that when you have a process that says you must be given the opportunity to apply for an attorney at magistration, this very first appearance in what we're calling court, but it's often a more informal setting, why it is, in fact, that at least in some parts of Texas, very few people end up with actually getting appointed counsel at all. And so this is fundamentally a study of what is happening on day one in some of these places that might be getting in the way of that process. So I'll call on Shelby in a moment because Shelby is the project coordinator for this work. She's done most of the data collection personally. She knows the data much better than me or really anybody else. But I'm in the privileged position of being able to talk about a lot of the findings. When you ask questions at the end, I may well call on Shelby again. But here we go, just to actually get our slides moving a bit. We're very curious about application processes. These are the processes that, at least in most places in the United States, stand as a practical and logistical matter in between defendants and getting an appointed lawyer. In some places, application processes are very simple, and they can be used to identify the person who's unable to afford legal representation. They can work very quickly, and they can therefore guarantee a person's constitutional rights. It is also possible, kind of infamously in our field, that depending on how you administer the application process, how complicated you make it, the process for a defendant to say, I want a lawyer, can be made cumbersome enough that you can end up unfairly denying lawyers to people who can't afford them. You can impose delay on the defendant and their access to counsel, and I suppose the case more generally. And in some places, there are certainly documented examples of local officials using onerous application processes as a way to control and reduce the spending on lawyers themselves. And so in some places, using application process as a way of discouraging people to actually ask for appointed counsel is a policy instrument that is used to reduce spending on indigent offense. Plenty of research on that if you're interested. So we're very curious about these application processes because when you come into court, everybody potentially is eligible for an appointed lawyer. And what we know in Texas, as we'll get to in a minute, is not everybody gets one. But first, I want to turn over to Shelby. And Shelby, please tell people what data we got.
Yeah, so we collected data from jail records, court files, and also a person's local criminal history. In some places, this data was available on paper and required us to physically scan documents in person. And in some places, it was available electronically. After collecting the data, we had an awesome team of undergraduate research assistants who recorded the data on a protocol, which you can see on this portion of the screen. They went through a very rigorous training process. And this document's actually 6 pages long. So lots of data that they recorded. And that data was then checked by a different student. And then I would review whatever they did not agree on. And then some of the key variables that we collected were the different types of attorneys people had at 3 different stages in their case. So we have magistration, arraignment, and disposition. Applications for counsel and the information that we fill out on those. Key dates in the case outcomes and sentencing information, and also the frequency of detention throughout their case.
Thank you so much, Shelby. Shelby has just summarized 2 years of work in just really 90 seconds. Thank you so much. There's much more that could be said. But yes, we end up with a very rich data set. And I think uniquely compared to a lot of other data that people work with in our field, we do have these, the defendant's representation status at several different points in the case. At least in research literature, it's most common to compare defendants on the basis of the kind of attorney they had when the case was disposed. So were they at that time represented by a court-appointed attorney or some other kind of attorney or no attorney? We have data in this project on not just the type of attorney when a person's case was disposed, but also also the type of attorney that they had at these 2 earlier stages in the case and whether they applied for one and when that happened. So we can really see with these data the process of people getting attorneys, and we can use that to identify where some of the bottlenecks are, or as the metaphor that we prefer to use, off-ramps. So here we go. Some processes are a straight shot. I am going to double down on this metaphor of driving routes quite a lot in this presentation. Some processes for getting a lawyer are a straight shot. They connect people straight to the lawyers that they need. I have certainly been in the court, and probably some people here have as well, where a defendant is brought into court for the first time. The judge simply says, "Do you want an attorney?" And the defendant says, "Yes, I can't afford one." And the judge says, "Ms. Smith or Mr. Jones, would you act as the attorney for this defendant?" And it's done. The appointment can be that simple in some places. But in a lot of places, it isn't that simple. In the example that I just gave, the judge didn't even bother to check whether the person wasn't able to afford an attorney. They didn't ask them to fill out any paperwork. They happened to have an attorney right there who they could actually call on to do the representation. And if those pieces aren't all present, then it creates effectively roadblocks, or what we actually call off-ramps to the process. We think that what we detect in these processes is that whereas all defendants come into the process potentially eligible for appointed counsel, assuming that they are jailable and in Texas courts, we have these county level courts that are only handling jailable misdemeanors. So we know all of our defendants are sort of eligible for appointed counsel in principle, but some of them, in fact, don't get it. So what are the off-ramps? Why aren't people applying for it? And why aren't they ultimately getting it? We ultimately zero in using our data on 3 off-ramps, in fact, and we're going to switch to going left to right. So think about it this way. If you're in a court like the ones that we're working in, 100%, these are misdemeanor courts, but every offense is jailable. So 100% of the defendants who come into that court could apply for appointed counsel, but some percent don't even bother. Right? In Texas, anyway, it says in the state statute that you've got to fill out a financial affidavit. That's not necessarily true everywhere. But here, what you want to see is people applying if they want counsel. And so some of them just don't. An unknown percentage, at least in this schematic. And then you've got, some people make it through that process. And let's say you do apply. What we see in some of our courts, and this is something that we'll be really interested to dig on, some people who applied applications aren't properly handled or properly processed. So in spite of applying, another off-ramp for even if people do get through the first decision of applying, the second off-ramp is that, is your application going to be handled properly, and is a decision really going to be made on whether you're even eligible for appointed counsel or not, and whether you can get one and will an assignment happen? And let's say you make it through that, and now your application has in fact been properly processed. The final off-ramp that we can easily identify is some people's applications are denied. Applications are denied, for those who are unfamiliar, most typically because people having applied are found to be wealthy enough to hire their own lawyer after all. And anybody who is deemed wealthy enough to hire their own lawyer is therefore not eligible for court-appointed counsel. And so what happens is, if you had 100% of defendants eligible, you've got at least these 3 ways that they can get off the pathway that would take them to getting a court-appointed lawyer. And after all of those processes have gone through, you end up with some percentage of defendants at the end who actually do get a court-appointed lawyer. We'll come back to these processes repeatedly. You may already be intuiting that they are all quite different. The not applying thing is quite different to you applied and your application wasn't properly handled, which is also quite different to your application was properly handled and you were found to be ineligible. Nevertheless, in simple empirical terms, this is a pretty good summary, we think, of how that 100% goes down to some other percent of people who actually get counsel in the end. So bear that schematic in mind. This is where we preview the report that we are expecting to issue later this month. It's called Getting Magistrations Right. As I said, Magistrations is the name for the first appearance in court in Texas. What it starts with is this graphic. What this graphic is doing is it's ranging all 254 counties in Texas across from left to right. And it's starting on the left with the counties where almost everybody does, in fact, get some kind of representation. So that's zero, but the scale on the left is the rate of non-representation. And so if you're down by zero, that means that most defendants in your county are ending their case with some kind of a lawyer. And when you move over across the red and into the dark red, you got 62 counties on the right in Texas, where looking at misdemeanor cases, over 75% of defendants are ending those cases without a lawyer, not appointed, not retained, not any kind of lawyer. So this is a remarkable thing about Texas. You've got in the misdemeanor courts the complete range of places where every defendant is getting a lawyer and places where no defendants are getting a lawyer. This is a summary of data across 5 years collated. So it's a remarkable range. And when you think back to the schematic that we just looked at, what that means is there are some places that have a straight shot where 100% of defendants are eligible for counsel and they all get it. And there are some places where those off-ramps are so enormous that by the time you get to the end of that process, no defendants have counsel for years at a time in some of these places. So Texas is, in other words, host to almost a complete range of possibilities that you could have in terms of systems that are functioning smoothly. Well, they may be functioning smoothly, systems that are functioning to get lots of people counsel, and systems that are functioning to give it to nobody. So that's what we're trying to understand. We do this, I mean, this is a graphic of all the counties in Texas. We dug in on 4 of them. We call them Cactus, Tumbleweed, Bluebonnet, and Longhorn. They are anonymized here. The point about sharing some of these data on what the counties is not to allow you to identify them. You actually shouldn't be able to identify them. In fact, that's partly the point. These are, as you can see, relatively typical Texas counties. They are 2 of them quite rural. Most of the populations are relatively small. In Bluebonnet County, we have a small city, so that's a 200,000 to 300,000 county. But most of these, the reason these counties are so hard to identify is there are lots of counties like this in Texas, and there are lots of counties like this around the country too. So here you can see them compared on population and also the rate at which people have no lawyer at arraignment, which is also quite variable. There's no particular correlations that you'll be able to detect here, but this is just more or less to tell you that these are typical little Texas counties, mostly little. There's their poverty rates, and that's the actual caseload of the courts in each one of them. Again, not put precisely enough for you to be able to identify them. And in fact, if you were to look at Texas data, you would find that there are loads of counties that fit this description. So I'm going to go through the 3 off-ramps, and I'm going to use 3 of our counties to provide examples of these off-ramps and just show you how we actually then go on to quantify and understand this kind of this process by which we get from 100% down to something less than 100%. So what about the number who never apply? Well, we use something called, this is a Sankey diagram or an alluvial. This is what we're calling Cactus County. And you can see at magistration on the left, that there are, I had this in my mind a moment ago, but 500 or 600 cases in this data set. And when we look at magistration, and when Shelby and her students looked at the paperwork from magistration, she was able to find that in 58% of cases, nobody was applying for counsel at magistration. Something happened in those early sessions. This wasn't the one that were happening in a toilet, but nevertheless, something happened in these early court sessions where these defendants either decided not to apply, thought that it was, rationally and reasonably in their best interest not to apply, or something else might have happened. Somebody might have told them something that caused them to believe that it wasn't in their best interest to apply, or that they didn't want to. Famously, we don't have data on this in our project yet, but this is what you hear in the field, is that sometimes prosecutors will come up to defendants and say, how about I give you this unmissable deal? You don't need a lawyer to proceed with this case. And so people are sometimes sort of talked out of it. We don't know that that's what's happening, but what we do know is that of the 100% of defendants who came into court in Cactus County, more than half of them just never even bothered to try and obtain an attorney for themselves. So that's off-ramp number 1. What about applications not being processed? Now, this is very different, like we said. Applications not being processed, what we're trying to capture here is, let's say a person does file an application for counsel, but then it appears that that application is lost, never makes its way to what in Texas is called the appointing authority. The appointing authority may not be present at magistration, but that is the person who actually has the legal authority to say, yes, I will appoint a lawyer for you. Sometimes they're not the person who's actually at magistration, and they're supposed to be a process where they get the form later. And we have at least one instance, well, actually we have more than one instance, but if we look at Longhorn County, the instance of Longhorn County, a smaller county, we had 41 applications in Longhorn County. And at the end of that application, there was a place where the appointing authority was supposed to say, I'm appointing you a lawyer or I'm not appointing you a lawyer. And in 12 of those applications, there was nothing written down. And then when Shelby and her students traced forward to the arraignment of that same person later on, they found that 9 of those 12 never did get any kind of appointed attorney. We don't quite know what the story is behind that, but we do know that the paperwork was not properly completed, and we know that for the people who the paperwork wasn't properly completed, they were much less likely to get a lawyer than for the people who the paperwork was properly completed. In fact, you can see in the slightly whited out section here that where that appointing authority did fill out the end of the applications for counsel, it did happen to be a he, denied only one of them. So it's not clear that the applications were properly handled in this county, and certainly there are instances elsewhere of people applying for counsel where something logistical breaks in the system and they don't get it for no reason except that they were forgotten about. So that's off-ramp number 2. And last, applications denied. A different mechanism here, right? But sometimes applications are submitted and you say, I make $37,000 a year, and they say, we don't assign counsel to anybody who makes over 25. I'm sorry, but you're not actually eligible for counsel. So this happens in all of our counties, but it happens in particular in Bluebonnet County. You can actually see this chunk in the middle here of the applications that went in, 97 were denied. This is actually 40% of the applications in this county. It's the highest rate of denial of any county that we looked at. These applications are fascinating, these denials, I mean, because what you can actually see hinted at going out to the right of the 97 is that it divides into 3. Some of those people do end up with court-appointed counsel at a subsequent hearing. Some of them end up retaining counsel. You can perhaps see the sloping middle what is that, a snake slope going down to people retaining counsel, and then some go all the way down and they stay red. These people never get counsel at all. So at least some of the people who are denied counsel for being too wealthy never then go on to retain counsel for themselves. This is another off-ramp. Those people, none of them will get appointed counsel. So this is the process, again, the whole schematic, and we can summarize all of it in, again, Longhorn County. In Longhorn County, 75% of people never applied. They then also, so does that mean that 25% of people get appointed counsel? No, it does not, because after the 75% of people never apply, you then have a further 7% of applications not processed and 1% of applications denied. And the result is, well, do you end up with 17% of people getting appointed counsel? Actually, no, it's even more complicated than that, because in Longhorn County, when people come back to court at arraignment, which is the very last column here, counsel status at arraignment, some of them apply for a second time, and they are then given, or they're asked maybe for the first time, and they are given a lawyer at that point. And so this is the entire schematic with the percentages filled in, and this describes to you how you go in Longhorn County from 100% of defendants being eligible to get appointed counsel to, at arraignment, in fact, exactly 23% of defendants getting appointed counsel. So there's so much more that we could say about this. I hope it's been provocative to you. The takeaways for us are: access to counsel is blocked if people don't apply for counsel. So in that case, we should be thinking about, what are defendants being told in court? Why are they actually seeing that as in their best interests? It's very clear if you read Supreme Court decisions on this that they don't think it's in your best interest not to have counsel. Access to counsel is also blocked, second off-ramp, if applications aren't processed properly. So what should we be thinking about? Logistics, procedures, and accountability. These kinds of flaws to me are so silly. Why on earth would you ever have a situation that somebody submits an application is simply not completed or acted upon? So these seem like very solvable problems, but a very different kind of a problem to why people aren't applying to counsel. And then the third thing, sometimes applications are denied. I've put unfairly in parentheses there because there are reasons to have eligibility rules about people who are over income. It's not an indefensible rule, and it's certainly a perfectly legal one. But it is also true that if you set the income level at which a person is entitled to counsel in the wrong place, then you could end up denying people's applications unfairly. And you'll remember that I earlier talked about how in some places application processes have been used to control costs of systems, and that's the way that that's sometimes done. So what we should be doing here is thinking about how eligibility is judged. When the paper comes out, you'll see that we've got a number of recommendations in these areas about what counties, certainly in Texas, but anywhere else, should be doing to make sure that these application processes are working fairly and smoothly. And I we'll be back in 2025 because we do have on these red points on the right, these are what we should be thinking about. And I want to tell you affirmative, we're thinking about them. We have more research to do using the data that we've got to start to access this question about how eligibility is being judged, what the logistics pieces are, and what defendants are being told in court. So we'll be back to talk more. Thank you very much.
So looks like we have a comment from Lisa that's just a connection to Amanda's presentation that magistration is such a confusing term. So it's perhaps another implementation of forensic linguistics is getting us all to have the same words for the same thing, because it definitely does, and it's very noticeable in a group like this, like people saying like, oh, what is that word? And it's like, oh, my word for that is this, right? You know. But yeah, so I don't see super pressing questions in the chat. I do have some, but I will save them until the very end, I think. So that, you know, we can make sure that all the questions get in. So I'll hand it over to you, Andrew. Andrew Falk, sorry. Andy or Andy in my mind. I didn't mean to confuse you.
Well, good afternoon. My name is Andrew Falk. I am an attorney with Indiana Public Defender Commission. I have the privilege of getting to work closely with Torin on a number of projects, and I am excited to share with you this afternoon on, I came up with a tongue twister of a title, Noticing Languishing Lifers, LWOP Defendants Deserve Heightened Attorney Qualification Requirements. To start off this afternoon, I would like to tell you a story that I want to share with you just to begin to help you to feel the issue that I'm going to be talking about. The story is about a woman whom some of you may have heard of. Her name is Sharonda Jones. I hope I'm saying it correctly. In 1999, she was charged under the Anti-Drug Abuse Act with 7 felonies for drug-related crimes. Ms. Jones was a first-time offender. She'd never even had a felony conviction. And the allegations were based entirely on the testimony of her co-conspirators, who received reduced sentences in return for testifying against her. After a 5-day trial, the jury acquitted Ms. Jones of 6 of the counts, but found her guilty of 1 conspiracy charge. That was it. But the federal government managed to increase her sentencing range by adding multiple enhancements. Her court-appointed attorney, who had never worked on a federal drug case before, did not object to any of those enhancements. Under federal sentencing guidelines, those enhancements resulted in a mandatory sentence of life without parole. For years, Ms. Jones fought to challenge her sentence. She argued that her trial counsel was ineffective, but her efforts were repeatedly denied. At least one of her motions was filed just a few months late, and the court denied it on that basis. Eventually, and this is good news for Ms. Jones, eventually a woman from Dallas, an attorney named Brittany Barnett, and she's the founder of the Buried Alive Project. She petitioned for the release of Ms. Jones. After 16 years in prison, longer than any of her co-conspirators, Ms. Jones received clemency from President Obama in December of 2015. I tell this story to help you sense the problem with LWOP, life without parole, attorney qualifications, or the lack thereof. I can share a lot of data about the seriousness of the life without parole problem, and I will, but it's also really good to feel the problem too. Standards for court-appointed attorneys in LWOP cases might have made a huge difference for Ms. Jones. But let's think about some of the other reasons LWOP attorney standards are so important. First, as Ms. Jones' story begins to illustrate, a sentence of life without parole is a very serious penalty. If it weren't for President Obama's commutation of her sentence, Ms. Jones would still be in prison and indeed would be there for the rest of her life. Sentences for both the death penalty and life without parole require sentenced individuals to spend the rest of their lives in prison, leaving only in a coffin. LWOP usually just takes longer. As Texas Court of Appeals Judge Lawrence Myers has said, life without parole is merely another form of the death penalty, just a slower version of it. The cost of a life sentence is high for both the person and the state. One study concluded that it is $1 million expense to incarcerate a person for life. Releasing individuals early would lead to a savings of thousands of prison years and hundreds of millions of dollars, savings that could be positively invested in evidence-based crime prevention and intervention strategies. And the cost for the person, of course, in terms of opportunities lost, relationships forfeited, and the freedom, of course, that they lose is far higher. Medical conditions develop sooner among incarcerated individuals with disproportionately high rates of dementia, cancer, arthritis, and hypertension, as well as declines in mental health. As prisoners grow old, they also become more vulnerable to assault and the other type of mistreatment from younger prisoners. But second, not only is LWOP a very serious penalty, but one could argue that the standard for initial representation should be higher than in a death penalty case, because the death penalty review, appeal after appeal, where the merits will be considered and defendants' procedural errors may be overlooked, will be much more vigorous and thorough. As Justice Scalia opined in 2015, the reality is that any innocent defendant is infinitely better off appealing a death sentence than a sentence of life imprisonment. The capital convict will obtain endless legal assistance from the abolition lobby and legal favoritism from abolitionist judges, while the lifer languishes unnoticed behind bars. And that's where I get the title of my talk today. A third reason we need to take standards for LWOP attorneys seriously is because it is becoming a much more common sentence. LWOP sentences were relatively unknown a century ago, and it has become common only in the last several decades. LWOP sentences are advanced by both sides, by both the death penalty abolitionists, who understandably prefer LWOP to capital punishment, and by law and order tough on crime advocates, who see LWOP as a useful tool in deterring crime and keeping dangerous criminals away from society. Its growth can be readily seen on the numbers. It grew 66% between 2003 and 2020. There were almost 60,000 people serving life without parole sentences in 2020. It's authorized in all of the states except Alaska. Between 2008 and 2020, the female population increased by 43%, while the male population increased 29% in that 12-year period. The Sentencing Project has done good research on this, the source of those numbers. And interestingly, LWOP, unlike the death penalty, which is legal in only some of the states. LWOP is authorized in all states except Alaska. Interesting, it is most prevalent in 5 states: California, Florida, Louisiana, Michigan, and Pennsylvania. And indeed, half of the national population of people serving on LWOP are in those 5 states. Excuse me. Now, it's been widely reported that only 11 states have LWOP standards at all, standards for attorneys who are representing individuals where LWOP is at risk. If you're curious, those states are Iowa, Kansas, Kentucky, Massachusetts, New Mexico, North Carolina, Ohio, Utah, Virginia, Wisconsin, and Wyoming. I find it interesting to note that none of the 5 states with the highest number of people serving LWOP sentences, California, Florida, Louisiana, Michigan, and Pennsylvania, are from those 11 states that reportedly have attorney standards for LWOP cases. At the same time, and we'll talk about this more later, I'm not sure that list is entirely correct. So what about the states without LWOP attorney standards? One study on LWOP concluded that someone just out of law school can handle a life without parole case in Illinois or Nebraska. And they also concluded that in California, where a third of the prison population is serving some form of life sentence, minimum qualifications apply only in death penalty cases. So we certainly have a lot of work to do. I've been working to research LWOP standards for attorneys in various states. Unlike death penalty standards, which you can Google and find multiple organizations who have collected and analyzed data and standards from all the states, I found no compendium of LWOP attorney standards. One of the challenges in this research is that many states do not have specific LWOP standards. You can't just search for death penalty, unlike just searching for death penalty attorney qualifications, you can't just search for LWOP attorney qualifications. It makes sense to me that a state would have a standard for LWOP attorneys along with death penalty attorney standards and murder attorney standards. But from what I found so far, that's not usually the case. Instead, what states do have is they usually have murder qualifications along with their death penalty qualifications. They have murder qualifications that would cover many LWOP cases, but you can't easily find those when you're just looking for LWOP standards. For example, Massachusetts has a murder, quote, murder list that requires the potential attorney to have tried 10 jury trials to a verdict within the past 12 years. 5 of the 10 cases have to have been serious and complex. Massachusetts murder list application also requires people to have experience using expert witnesses, using social service professionals, etc. A second challenge to identifying LWOP attorney standards is that there is is that most states don't have a specific provision covering LWOP standards, and they don't have a list of offenses that qualify for LWOP. So you can't just go and say, okay, here are all the offenses for which LWOP is eligible. Most states that impose life without parole do so for murder, but defendants may also be subject to life without parole for certain types of sexual assault, for property crimes, and as we saw in the case of Ms. Jones, for drug offenses. So of the states that do have LWOP attorney standards, what do they look like? Well, I'm sorry, for the states that don't have LWOP attorney standards, what do they look like? What are their standards? We can look at Maryland, which basically provides that attorneys must be admitted to practice law and are qualified for the types of cases to which they are assigned. Another example is Louisiana. And Louisiana specifically mentions that its Supreme Court has established death penalty standards, but for everyone else, there's basically 2 simple provisions. First one, in order to provide quality legal representation, counsel must be familiar with the substantive criminal law and the law of criminal procedure and its application in the state. And they say that counsel has to have a continuing obligation to stay abreast of changes and developments of the law. And then the second one is, prior to agreeing to undertake representation in a criminal matter, Counsel should have sufficient experience or training to provide effective representation. Sounds good, but if you begin to think about it, okay, what does that actually mean? And how would an attorney know? How would someone know, okay, this attorney is qualified to take these types of cases? Is this attorney qualified to take an LWOP case? Michigan, which is not on the Sixth Amendment Center list of states that have LWOP attorney standards, has a slightly more robust definition and explanation of what an attorney has to have in order to take an LWOP case. They say that they list their basic requirements for what an attorney has to have. They have to be licensed to practice law in the state, as you would expect. They have to comply with basic training requirements, and then they have a specific provision for quote life offense cases. And for life offense cases, the attorney has to have practiced criminal law for 5 full years, either as a prosecutor, public defender, or in private criminal defense practice. They have to have prior experience as lead counsel, no fewer than 7 felony jury trials that have been submitted to a jury. And they have to have a significant record of consistently high quality criminal trial court representation and the ability to handle a life offense case. Again, attorneys would could be what do you say? Figure out a lot of ways to fit within that, or to argue that an attorney is not qualified, but that's what Michigan provides. Washington State, another state that is not on the list of 11 states that are the only ones to have LWOP cases, has some of the most detailed LWOP attorney standards. Among its requirements are that an attorney with representing individuals subject to the LWOP sentence have to have 4 years of criminal trial experience. And they specify, it's not just enough to be a prosecutor. They also have to have at least 1 year of experience as a felony defense attorney. They have to have experience as a lead counsel in at least 1 Class A, the highest level of felony trial. And they have to have experience in certain types of offenses or cases dealing with mental health issues, sexual offenses, if the current offense is related to that. And they also have to have experience dealing with expert witnesses. And they have to have a year of appellate experience or demonstrated legal writing ability. So Washington State has done some good work in thinking through, okay, what types of experience is required. Now, Maine is one of the many states that does not have specific LWOP standards, but it does have murder standards, which most LWOP cases are. And this is fairly typical for many states in what they require for murder qualifications. Their standards include the provision that an attorney has to be have at least 5 years of criminal law practice experience, have tried before a judge or jury as first chair at least 5 felony cases within the last 10 years, at least 2 of which were serious violent felony, homicide, or Class C or higher sex offense cases, and at least 2 of which were jury trials. They must have tried as first chair a homicide case in the last 15 years, or tried as second chair at least 1 homicide case with an experienced homicide defense attorney within the past 5 years. And again, they have to demonstrate a knowledge and familiarity with the evidentiary issues relevant to homicide cases. And then Maine goes on to say, hey, we want you to get some referrals, some recommendations, at least 3 letters of reference from attorneys you don't practice with, and asserting that this applicant is qualified to take these types of cases. So those are some of the types of standards that states do have. Let's think a little bit about what the death penalty standards are. And this is, you can find this relatively easily, unlike the LWOP standards. And this is just a quick and dirty overview of what many of the states require. In many states, unlike LWOP sentences, 2 attorneys are required. in most, if not all of the states, specific death penalty courses ranging from 6 to 15 hours are required. At least 5 to 10 years of criminal experience are required. In most states, 8 to 10 felony jury trials are required. And in most states, prior death penalty trials are required. So having looked at a few states with LWOP standards and having thought a little bit about the death penalty standards, what would an ideal LWOP attorney standard look like? Now, it's important to keep two things in mind here. On the one hand, we don't want to make the LWOP attorney standard so stringent that then the state decides, hey, we might as well charge the person with a death penalty. On the other hand, recognizing how serious the penalty is, we don't want to make it so weak that we don't protect individuals such as Ms. Jones, whose attorney failed to do a lot of things that could have really saved her from receiving the life sentence in the first place, life without parole in the first place. A panel of defense experts in Indiana has proposed an LWOP attorney standard. And as I share this, I want to make sure that you understand that this is something that is in the early stages. It may be changed significantly, but it's a start. This draft for LWOP cases provides that, unlike many of the states, it provides that 2 attorneys will be appointed. Both of the attorneys have to meet the qualifications of appointed counsel in murder cases, and one of them will serve as lead appointed counsel. To be eligible to serve as lead appointed counsel in a case where a sentence of LWOP is requested, an attorney shall, and there's 4 elements here, be an experienced and active trial practitioner with at least 3 years of criminal litigation experience, have prior experience as lead or co-counsel in no fewer than 3 felony jury trials, have prior experience as lead or co-counsel in at least 1 prior case where a death penalty or a life sentence without parole was sought, and have completed within the last 2 years prior to the appointment at least 6 hours of training. And the training could be either in a capital case or a life without parole case. So just thinking about, okay, how does this compare to Indiana's death penalty case? The death penalty requires 5 years of criminal litigation experience. The LWOP requires 3 years. Indiana's murder requirement is also 3 years. The death penalty requires 5 felony jury trials tried to completion. The LWOP requires 3, but it specifies at a higher level. It's not just any felony; it has to be at least level 5 or above. And the murder requires has the same requirement, 3 at the level 5 or above. The prior experience for a death penalty case is they have to have previous experience with a death penalty. For an LWOP, they have to have at least 1 case where the death penalty or a life without parole was sought. For the murder, there's no similar requirement. And then in terms of training, the death penalty has to have 12 hours of training. The LWOP has to have 6 hours of training. The murder doesn't have any required training. And then both of the death penalty and the LWOP have 2 attorneys required, whereas the murder has 1 attorney required. So while Indiana has a proposed standard specifically for LWOP cases, I intend to continue researching and identifying LWOP standards in other states to the extent that they exist, and I hope to better refine this proposal. Our office is going to continue working on that. And I'm also interested in proposing a standard that could be a model for other states as well. If you have any suggestions for me, I'd be happy to hear them. My contact information is in this slide, and I'm also open to any questions that you may have.
Thanks, Andrew. I'll also add for all of our presenters, if you got the program that was sent out, everyone's name is a clickable link to their email as well. So even if you don't have the slides, you should be able to contact them and ask them whatever questions. So yes, we'll definitely open the floor now to any questions. You can drop them in the chat and I will read them, or a presenter will. Or you can feel free to unmute and talk. We have, I think, a small enough group that won't be crazy. And please do bring questions for any and all presenters. We do have a little bit of time here at the end. So we should be able to get through a decent amount of questions. And like I said, I do have a couple questions. The first one I wanted to ask is for Amanda. As I said, forensic linguistics is like completely unknown to me. I have heard a complaint before that, you know, the instructions that we're giving to people are not realistic, right? In terms of expecting everyone to understand it on like a really bad day. But so I just wanted to ask if you knew of any like attempts. So like as an example, there's you probably know way better than me as someone in linguistics, but there's like the Simple English Wikipedia, right? And so like I've looked at articles on Simple English Wikipedia, which is a very limited vocab set. It has different goals, I think, and couldn't be the exact same vocab set, but they describe like pretty complicated concepts in very simple English. Like, has anyone attempted to make like a standard of anything in the legal field? Because I've certainly not heard of it. I'm kind of surprised.
I think yeah, like I don't know totally specifics because the plain language kind of movement hasn't really been my focus in the past, but it's basically like the plain language movement. And I know there's been work done particularly on jury instructions, and trying to make that kind of simplified. A lot of it just because, like I pointed out in the presentation, like a lot of it comes down to simplifying sentence structures, because you can kind of get lost in the hypotheticals and like conditionals that happen in the law of like when you're coming to a decision as a juror or when you're being presented something. But yeah, so I think that's been implemented or attempted to be implemented in a few states. I know that there are like at least scholars working on it. And then simplified Miranda rights are definitely at the forefront, especially for juveniles. But yeah, so it's ongoing. But there's I don't know of anything that's been like widely standardized yet.
Well, that's good to hear. That's better than I initially expected, that people have been working on it. Because you'd think it would be something that like everyone involved would want. Like it seems like it makes everyone's job easier in a lot of ways.
Yeah, I think it's just the slow movingness of the system basically at play, and convincing people that the original language is too complex, I think, is also a step.
Yeah, I mean, it just seems like even if it's not too complex, like what are you losing? You're just like you're probably saving time at least, and how long it takes to say these things. Or anyway, thank you. And again, okay, so a couple questions just came in. One from Claire. Have any studies asked defendants after hearing to repeat what they agreed to, like what their sentence is, as an example, as a way of measuring comprehension?
Yes, I'm not sure. So if Alisa were here, I would pull her. But her studies that are kind of part of this larger project have had other research assistants interview people after they come out of the arraignment hearing to kind of explain what they just agreed to and what they just pled to, and kind of what the agreement was. Because of the constraints of conversation analysis really being like exactly within the data only, I've avoided looking at those yet because I don't want them to affect how the analyses go. But there, I can say that in studies of like Miranda rights and things like that, where there's one by Pavlenko in 2019 where they have them paraphrase back the rights, and it's a very low percentage compared to how confident they feel in understanding their rights. So people tend to be overconfident in their understanding of the legal processes.
That makes a lot of sense. Another question came in on similar lines from Marcela. Has there been work done in the forensic linguistics field on the added level of complication added by translating or interpreting Miranda and other standard advisements into other languages, Spanish, for example?
I can't think of it. There definitely has. I know more of work that where it's like checking kind of non-native speakers in their understanding of English Miranda rights, but there's also kind of, I can't think of any particular studies right now. I'm sure they exist, but there are also like many anecdotal things that come up where translations are not necessarily done by people who are fluent enough in the language. So when police officers sort of attempt in like broken Spanish or broken whatever language it is to explain the Miranda rights, and somehow those get accepted as like adequate waiver of rights from that. I think kind of the basic issue is that translating is never 100% the exact same meaning. So there's kind of a casual attitude towards translating the rights within kind of policing now, and it needs to be more kind of formalized, I think, is the basic sentiment.
Thank you. And once again, I hope we see the rest of this stuff that you've been talking about. Please do bring it back to us, because we're definitely super interested. Lisa has her hand raised.
Thank you, Torin, and thank you to all the presenters. I wanted to ask you, Andy and Shelby, if your work, the reason behind like doing your research was related to like a call in Texas or specific counties that too many people were getting appointed counsel and there was like an overuse of it. I have heard that in other localities, and I didn't know if that had something to do with the selecting of your research topic. Meaning that like people were getting public defenders when they weren't otherwise eligible financially.
I think that certainly that didn't motivate the research. I don't know how you'd respond to this, Shelby, but I think that when it comes to the question of how many people are getting counsel in a place, there are sort of cycles that some jurisdictions go through where they decide to crack down on the question of eligibility and become convinced. We have at least one public official in one of the sites where we're working who is convinced that defendants chronically lie, and that they are put in the position of choosing to either audit a person's entire finances, which would be impractical, and that's actually specifically been studied also. I mean, when jurisdictions attempt to invest in auditing all defendants' finances in order to find out if they truly qualify for counsel, the cost of doing that is usually more than just giving everybody a lawyer anyway. But there are people who believe that lots of defendants lie and that they're giving counsel to people who could otherwise afford it. Our concern is not that really. We did an earlier report 2 years ago called Getting Gideon Right, which established that in all but 254 counties in Texas, and according to our analysis, in 252 out of 254, the rules as written would require people who have less money than they need to make ends meet to hire their own attorney. So our critique has been that most of the time when you examine these standards for eligibility and financial assessment, they're too stringent and they're denying counsel to people unfairly. When you hear these critiques and when you see these policy experiments, it usually results in this conclusion that actually investigating people's finances costs more than giving people the lawyers anyway. But that doesn't mean that it is not also true that there are always people out there who think that we're giving people to lawyers who are just lying about the fact that they could afford one if they really wanted to. There have also been people who have attempted to identify defendants' finances in order to find out if they really are lying. The one study that I always come back to is from Nebraska, and it found that to the extent defendants were misrepresenting their finances, they tended to represent themselves as wealthier than they are rather than poorer than they are, suggesting that no strategic pleading of poverty was going on, at least in that study. So I think the evidence for that really happening or really mattering or having any policy importance at all when you go through the thought process of what it would take to remedy it is really low.
See, Josh has a hand raised as well.
Yeah, thanks, Torrin. And thanks everybody for presenting they were all fantastic. I also have a question for Andy and Shelby. If I was reading your graph correctly, the one that was basically, showing the off ramps with the different colors, it looked like there were the number's pretty small, but it looked like there were a few defendants who had applied for an attorney. Their application was granted or approved, and then by the time they got to arraignment, they were without an attorney. If I was reading that correctly, I was just wondering if you could, maybe expand on that just a little bit, what those situations were, and what was going on there.
Shelby, you want to do this one?
Yeah, sure. So when that's happening, sometimes we see like a substitution order, which in this case is less that they're substituting for a different attorney and more that they just aren't getting along with their attorney. So I don't think it happened a super big amount of times, but when it did, it's usually that. It just shows that the attorney withdrew. We don't have a ton of information about why they withdrew, but I would assume that it has to do with relationship to the defendant. Sometimes this is going beyond the scope of your question, but if you see them move into retained, sometimes they got appointed, but then decided they actually wanted to hire their own. And then sometimes you can see them bounce around again, like if they changed attorneys, which our Sankey doesn't show.
These graphs are actually live, Josh, so I thought it might be fun to just show them. I mean, you can see people, for example, getting denied, and when we publish the report, these will be available for people to play with and do the kind of deep dive that you're interested in doing.
Okay, great. Thank you both so much.
I'm going to take the moment where there isn't a question to jump in my own, Andy. And this is kind of follow up from Lisa's, because so Indiana is in fact one of those states that we basically just had legislation passed that is going to require a standard indigency form at least be piloted. And that indigency form is going to be written by the state courts essentially. And so I think we are at a good turning point for that. The motivations behind that form were entirely those that Lisa brought up, was that there were legislators that believed people were getting appointments when they shouldn't. But I do think it could be a kind of blessing in disguise. And I wanted to ask specifically if you guys had any feedback from localities in terms of proposing that kind of solution, because I haven't asked anyone here, but I'm guessing we would be 50-50 between judges who don't want they stay out of my courtroom, and then the other 50% being thank you, I've been just doing this on my own all along, and I don't want it I don't want to be in the business of this, right? So I'm curious what your perceptions have been, and if you have any other thoughts on that. And I'm definitely going to be emailing you for some of those papers, because that will be helpful.
Taryn, is your question whether people would welcome a standardized form, or whether
yes, exactly. Yes.
Okay. Whether they would welcome a standardized form. Yeah, Texas is one of these places where it is diverse across the state. In New York in 2016, I went through a similar process to what you're describing, because they had not just county, but individual courts using their own forms, and they introduced a standard one. I think there's actually quite a lot mixed up in what you're saying. The idea of judges saying, I wish I wasn't responsible for this tedious administrative headache, or indeed this responsibility of making this momentous decision of actually denying people counsel, that's a real concern that I hear from judges quite a lot. They would really rather that there was somebody else to handle this, because they even feel conflicted at times. A lot of the judges that we've talked to actually want to give counsel to people more than they're allowed to, which is not what some people imagine they would say. So that sentiment of sort of, I wish there was a system or somebody else to handle this for me, I think is really, I recognize that. The idea of standardizing the actual income level, and wishing that was the same was true everywhere. I don't know if judges particularly are attached to that idea, but the idea of not wanting to be responsible for it, particularly because they feel there's a conflict in their role, which there is. I actually think that's right. I mean, there's at least the conflict of they're now going to decide if a person in their court has counsel. In Texas, there's the specific conflict in county court that the county court judge is very often also the chief executive of the council, who is the person who therefore is on the decision-making body who makes the ultimate determination of the indigent defense budget for the county and is himself elected, or herself, although this is Texas. So they're mostly male presenting. So there are these kind of conflicts that exist between being asked to make that decision and also being in the position of the judge. And the third obvious conflict is that occasionally in the application process for counsel, you have discussions that you need to have with somebody that you have a privileged relationship with. So if you're going to say, I mean, there's a beautiful example in a book that I've got on the shelf here of a magistrate judge in Texas saying, what do you do for work? And the defendant saying, Judge, I steal cattle. And the judge saying to the defendant, I don't know what the prosecutor's going to do with your case, but I'm going to tell him you're the most honest goddamn man I've ever met. So that's the other conflict, right? This is really, really rare, but occasionally people actually end up confessing to crimes. Shelby and I saw a person who wrote there's an application form out in West Texas where you're supposed to write what you're charged with. And the person wrote, I was charged with transporting migrants in my car, illegal migrants in my car. The judge mistranslated the Spanish to say, I transported illegal migrants in my car. And so she interpreted it. She didn't interpret it this way, but in my interpretation of her interpretation, she was looking at a signed confession. It was a mistranslation. So there are all kinds of reasons that I think judges actually should not be the person, but as a practical matter, they almost always are.
Well, thank you for all of that extra detail. We're actually over time slightly, so I thank you all for staying a couple extra minutes, and thank you all for presenting. We start tomorrow at noon for those of you who wish to come back, noon Eastern, that is, and it's just at this exact same link. Again, thank you to all the presenters, and I hope to see some of you back tomorrow to see talks, and then several of the presenters to be back next year to present some more.